All right, good morning, everybody. It is 9 o'clock, so we are going to get going with this webinar. We already have one person submitting a question. So I love, Laura, the fact that you have gotten your question in early, and we will attempt to address your question and all others that come in throughout the course of today's discussion. Today's discussion is about Act 207 and the sale of tax foreclosed properties. My partner, Matt Tome, is joining me here today. And I think, Matt, you've probably spent a lot of time thinking and contemplating Tyler v. Hennepin County and Act 207 for the past year, probably, that we've been dealing with this issue. So we know that there are lots of questions out there, lots of information, and lots of concerns about the process and procedures. And hopefully today is going to give an overview of what Act 207 does not do, and what counties need to consider when it comes to the disposition of properties that counties acquire through the tax foreclosure process. Just a couple of housekeeping items to begin. On your screen, there are buttons Q&A and chat. You can use either of those buttons to ask questions of me and Matt. We want to make this as useful as possible to all of the attendees, and so feel free to ask questions. And if we cannot give you an answer right away, we will certainly do our best to get back with you to provide you with the information that you're seeking. Second, this webinar is being recorded, and so it will be housed on WCA's website once the recording becomes available through the Zoom process. And so if you have others in the county that are interested in seeing this presentation, feel free, once that link is operable through WCA, to share that link with them, and we can go about doing that. I think that's it for the housekeeping, the general introduction. Matt, what else do you want to talk about? Anything?
No. Well, why don't we jump in?
A man of many words. That's what I always say about Matt. All right. So here's our agenda today. We're going to talk about the U.S. Supreme Court case in Tyler v. Hennepin County that was released last year. It was in summer of 2023. So we're going to talk about that case and what it means. We're going to talk about Act 207, which is a legislative response to the Tyler v. Hennepin County case, and also a legislative response to some of the issues that were prevalent in 2021 Act 216. And then we're going to go through some common questions and concerns that we have heard as it relates to Act 207 and Tyler implementation. So let's start with this Tyler v. Hennepin County case. And we're not going to go through a detailed analysis of what the case does, but I thought it would be important to really highlight here what the court is saying in Tyler v. Hennepin County, because the reason this is important is that Act 207 compliance does not guarantee compliance with the Constitution and the Supreme Court's decision in Tyler v. Hennepin County. Compliance with Tyler v. Hennepin County does not mean that you automatically comply with Act 207. And so it's important that we understand that the Tyler v. Hennepin County case exists independent of Act 207, even though Act 207 provides a mechanism for implementation of what the court was holding in Tyler to an extent. But just because we comply with one or the other doesn't mean we get to say, okay, we're good. And I just want to make that clear at the outset that you have both of these to consider. And so if we look at the very basics of the Tyler case, and these are quotes directly from the decision, and by the way, it was a 9-0 decision at the U.S. Supreme Court. So rare that we would get unanimity on a case. This case got unanimity from all factions of the court. So in the actual decision, it says the county has the power to sell Tyler's home to recover the unpaid property taxes, but it could not use the toehold of the tax debt to confiscate more property than was due. In the Tyler case, what you had is Hennepin County, Minnesota acquired a tax deed to property based upon $15,000 of unpaid taxes. The home had a value of $40,000. And so when the county acquired the deed and sold that home and retained the $25,000, the U.S. Supreme Court said your retention of the excess proceeds associated with the sale, excess being defined as that which is greater than what is owed in the back taxes, constitutes a takings under the United States Constitution. And the remedy for a takings is just compensation. What's just compensation? It's the $25,000 excess. And so essentially the United States Supreme Court took the opportunity in Tyler to say that counties in Wisconsin and all around the country cannot maintain or retain any excess proceeds from the disposition of tax foreclosed properties. The court continued and said it affected a classic taking in which the government directly appropriates private property for its own use. And you'll see the quote there, a taxpayer loses her $40,000 house to the state to fulfill a $15,000 tax debt, has made a far greater contribution to the public fisc than she owed. The taxpayer must render unto Caesar what is Caesar's, but no more. And so that's the essential holding in Tyler and what Tyler means. But I think it's also important to look at some of the questions that Tyler did not answer. All right. So when does a taking occur? And that's important for purposes of a constitutional analysis, because the question is, does the taking happen when the county acquires the deed to the property? Or does the taking occur when the county disposes of that tax deeded property? And you may say, well, why is that important? Well, I know that there are many counties out there who are sitting on tax deeds that they acquired years upon years upon years ago. And so depending upon how a court would evaluate when the taking occurs, that is going to determine when just compensation is due to the former owner. Again, that's not answered in Tyler. Matt and I have our own theories on this. We're not going to get into the weeds on those theories here, because again, this is being recorded, and this is certainly not the forum to get into some of those weeds. But I highlight this because there are questions that were left unanswered emanating from the Tyler decision. Matt, anything you want to add on that?
No.
You're supposed to jump in here from time to time, Matt. Feel free to do that. All right. Second question. How is the property valued for purposes of determining when just compensation is owed? And you may say, well, what do you mean, how is the property valued? We sold it. So whatever we got in the sale process, that's how the property is valued. Well, maybe that could be. How do we guarantee it's an arm's length transaction? We know that the best determinant of fair market value is the sale price in an arm's length transaction. But what if we don't have an arm's length transaction? What if the property is distressed? What if we have, again, a situation where you've sat on the deed for a period of time such that the market took a dip and what you received as the sale price is far less than what you would have received 2 years ago under similar conditions? Is that type of an evaluation, is that important for purposes of Tyler implementation? Again, we don't know the answer to that. We do have some solace in the fact that the Sixth Circuit Court of Appeals has recently concluded that an arm's length fair market value determination, a fair market value determination through arm's length sale is considered value. In other words, you do not have to get highest best sales price in order to satisfy your constitutional obligation. That said, though, we don't know how the United States Supreme Court is going to look at particular valuation questions. And then finally, does the Tyler case, does it require the sale of property? And Matt, I'll let you jump in here in a moment. I don't think it does. And the reason I say that is that in a traditional condemnation or takings case where the government acquires property, what you go through is an appraisal process to determine the value of that property, and then you pay the property owner the value of that property. That's the just compensation for the taking. There's no sale in that condemnation process. In this circumstance, where we've got a property acquired by tax deed, if a county, for example, wants to retain that property for purposes of its own inventory, whether it wants to use it for parkland, put it in managed forest land, whatever the reason that the county wants to retain the property, I think it can still do so. But you ought to have a very good appraisal process to determine what that property is valued at. And then if that valuation results in excess proceeds, meaning that the value of the property is more than what's owed in the back taxes, plus fees, charges, interest, and so on, then that excess has to be returned to the former owner. But I think a county could do that if it wanted to go that route. Matt, your thoughts on that?
No, I agree with that constitutionally all that's required is to ensure that the taxpayer is getting just compensation for their property. I would just highlight that this is probably an area where, as you mentioned earlier, compliance with Tyler doesn't mean compliance with state law. And as we're going to discuss in a little bit, state law now generally requires that the property be sold. And I mean, and second, I would just say as a practical matter, if you were going to go that route of paying the excess so you can retain the property, essentially tax foreclosure would just become a method to purchase property by the county at a reduced sale price, if you know what I'm saying. Counties would be paying to in effect enforce their tax laws and to collect on the tax debt. Because they would have to pay that excess compensation out of their own fisc because they wouldn't have generated it via sale. So, I mean, as a practical matter, I don't know how many counties would actually do that, pay the just compensation to retain the property, but I think you could do it and comply with Tyler.
Yeah, and I think that's a good point, Matt, that again, it highlights or underscores the importance of our introductory comments that compliance with Tyler doesn't necessarily mean compliance with Act 207 or a state law mandate and vice versa. Act 207, as we soon will see, does impose a sale requirement on the county. We have to talk about what that means, and we'll get into that in a moment. The final thing I just want to mention on Tyler is that Tyler was prosecuted. Mrs. Tyler was represented by the Pacific Legal Foundation. That's a special interest group that is that finds personal property rights, real property rights, very, very important, and it is going to litigate questions arising under the Constitution about governmental takings. That's what Pacific Legal Foundation does. Pacific Legal Foundation targeted several states following the Tyler decision. Targeted meaning that they said state law did not adequately preserve or protect property interests in light of the Tyler decision. Thankfully, Wisconsin was not on that list. And so in other states, you saw class action lawsuits arise out of the Tyler decision. For example, in Minnesota, there were I believe it was three separate class actions that related to implementation of Tyler. We were always concerned, Matt and I were always concerned about, well, what does that mean for Wisconsin? And again, this is not the forum to get into what ifs and legal theories and get into those weeds. At the same time, I'm thankful that I'm not aware of, and I don't think, Matt, you're aware of, any sort of widespread litigation going on about Tyler implementation in Wisconsin. Any comment there, Matt?
No, and I mean, I think in terms of the concerns that we had, I mean, they've been briefed. So, you know, I think our concerns at the time related to the fact that under Wisconsin law, there wasn't a requirement that you sell the property. Right. So you could have situations, as we just discussed, where you had the property retained. And then just second, issues relating to people's loss of right to surplus proceeds under the prior act. I believe it was after, was it 5 years, Andy?
Yeah, within 5 years, Act 216, yes.
Right. And so then you would run into, you know, but the question of whether or not 5 years is a long enough period
Right.
for purposes to lose a surplus, right to surplus proceeds. So as Andy will probably get into in a second, Act 207 was in large part addressed to resolve those two issues, as well as potential issues coming out of Act 216.
Correct. So why don't we segue now into Act 207 and what Act 207 did? And I want to set the table for everybody here. I mentioned briefly 2021 Act 216. Act 216, as counties might recall, was a significant change in Wisconsin law as it relates to disposition of tax foreclosed properties. As counties might remember, there was no right to any of that surplus associated with the sale of a property that existed under Wisconsin law prior to Act 216, unless that property was homestead property. Act 216 changed that and said that all properties are eligible, all former property owners, regardless of the character of that property, are eligible to receive those excess proceeds as a result of sale of the property. And Act 216 was ambiguous in terms of the county's requirements, and it was difficult to implement because it used terminology that wasn't necessarily precise and didn't exactly speak to what a county was required to do in order to find, locate the former owner, send those proceeds. And as Matt indicated, you have to hold on to them for 5 years. There was a provision in there about paying out lien holders, when in actuality, the tax foreclosure process wipes out liens. So in theory, there are no lien holders that existed at that time. And so Act 216 presented some logistical problems in implementation, and on top of being a completely new process for counties. And so the Treasurers Association, Corporation Counsel, WCA, we all got together and started talking about what do we need to do in order to clean up some of the problems that we see with Act 216, not necessarily changing the substantive law. In other words, the return of proceeds to the former owner. Okay, we get that, but the procedure we utilize to get to that point is what's unclear in Act 216. So how do we clean up some of what Act 216 created in terms of ambiguities vis-a-vis future legislation? So we started discussions with and the primary entity that was interested in Act 216 cleanup, interested in Tyler implementation was the Wisconsin Realtors Association. And so we had had discussions with the Realtors Association about potential cleanup measures. I will tell you that the legislature was very interested in implementing Tyler and very interested in Act 216 cleanup. I can tell you that the administration was equally as interested. So when you've got a legislature interested, when you've got an administration interested, and when you've got a powerful lobby, that being the Realtors Association interested, you can pretty well be sure that there is going to be some sort of legislative response. And so again, it was through the course of discussions that we tried to address some of the concerns and issues with Act 216, address this whole issue of Tyler implementation, and what we ended up with is what is now Act 207. I will say, and I think WCA, Matt, everybody will agree, Act 207 is not perfect. There are problems and holes in Act 207. Again, this is not the forum to get into the specifics of some of those issues, but Act 207 is not perfect. And I think there will be additional opportunity to address this issue in Act 207 and the issues surrounding Act 207 in future legislative sessions. So I don't think our work on the legislative front is done. That said, Act 207 is law, and we as counties have to comply with the law. And so let's talk about what the law requires now. So again, just noting that the legislature was anxious to codify a requirement to sell the tax deeded properties. As we talked about earlier, I'm not sure that Tyler requires a county to sell the property. I don't think it does. And I think from a legal constitutional standpoint, as long as you pay just compensation, there's no requirement to sell. That said, the legislature, the administration, and the realtors were very, very intent on imposing a sale requirement on counties, notwithstanding that it wasn't constitutionally mandated. And that's again where you have to be careful sometimes, because I heard Act 207 being termed or named or called at various points implementation of the Tyler decision. I don't think it is. I think in many circumstances it went beyond what Tyler may require. So again, you just have to be careful about what people call things. All right. So as indicated, Act 207 requires counties to sell within 240 days. And let me back up. There's a requirement to sell the property. In the initial draft of legislation from the legislature on implementation of Tyler, they simply had a statute put together, drafted, that said a county is required to sell properties that acquired through the tax foreclosure process within, I think it was 60 or 90 days. That all sounds fine and good, but you need two people in order to conduct a sale. You need a seller and a buyer. If we can't find a buyer, you can't mandate a sale. And so one of the things that we started discussing is we understand the desire to require sale of these properties, but if we don't have a willing buyer, we can't effectuate that statute. So instead, let's provide a mechanism where we put the properties on the market using our best efforts to try to sell those properties. And that's exactly what Act 207 ended up looking like. So again, within 240 days, and then at the beginning of 2026, within 180 days of acquisition of a tax deed, the county has to advertise the property for sale. Now, you might remember that pre-Act 207, there was a publication requirement, 3 insertions in the paper, and so on. And we spoke with the legislature, the realtors, and the administration about trying to relax that process a bit, because frankly, everybody's interest is to get this property on the market out there so that everybody understands it's for sale, and putting it at the back end of Section C of the newspaper isn't necessarily going to accomplish that. So let's look at alternative methods of providing notice to the public. And so Act 207 updated that publication requirement and said, we can put it out for sale. We're going to put it on our website, and we're either going to provide a Class 1 notice, which is 1 insertion in the newspaper, or we're going to advertise it through MLS. And so again, that notice requirement letting the general public know that a property is for sale. That has to happen within 240 days of taking a tax deed or 180 days of acquiring a tax deed beginning January 1, 2026. I'm going to stop for a second there and just note that there is a different provision that applies to Milwaukee County, including the city of Milwaukee. That's because the city of Milwaukee maintains a special program as it relates to properties acquired through the tax foreclosure process. And the legislature did not want to interrupt or upset those special programs. And so when we talk about the requirements of Act 207, for anybody who's listening from Milwaukee County, not unlike various other parts of the statutes, there are special rules that apply to Milwaukee County and the city of Milwaukee. Here's the other important part, is that Act 207 had an effective date provision at the end of the act. And this is common in legislation. Typically, you'll see that legislation takes effect after passage and signature by the governor following the publication period. That's all fine and good. But a lot of times in legislation, you'll see this act shall be effective beginning on X date or whatever the case may be. Well, Act 207 had an effective date provision. And it says that the publication requirements as it relates to properties that are acquired through the tax deed process, the publication requirement is imposed on properties that are acquired on or after April 1, 2022. All right, why is that date important? Well, April 1, 2022 is the effective date of Act 216. All right, but that deadline doesn't start until the effective date of Act 207, the 240-day timeline. And so we got a period of time there where, again, there was an attempt to say that we are not going to automatically put counties into non-compliance with the notice provision that's contained within the statute because of deeds that the county acquired before the effective date of Act 207, because Act 207 didn't carve anything out and say this is only applicable to deeds that you acquired before. The legislature, administration, the realtors were all very interested in making sure that counties clear their inventory of these deeds. And so we've had a lot of questions come up about what do you do about properties that the county acquired? I'm going to use an absurd example. What about a property a county acquired in 1993? And for whatever reason, maybe it's in wetlands, maybe it's just a sliver of property that's non-buildable. For whatever reason, the county has just maintained that deed in inventory. Is there a requirement to publish notice that that property is available for purchase? And Matt, I'll let you chime in here in a second, but I think under Act 207, the answer is, yeah, there is a requirement within Act 207 requiring you to indicate that that property is available for purchase. But there's also a practical impact here, a practical effect. If we're talking about a deed acquired in 1993, realistically, who's going to come back and claim that you didn't comply with the statute? Who has any sort of claim that you didn't comply with the statute? That is something that occurred 31 years ago. And so there's a practical component here too. I want to be very clear that neither Matt nor I are giving any legal advice to counties that you don't have to do anything with those 1993 deeds. That's not the point. The point is you need to have a conversation with your corporation counsel about how you treat those situations because it's not one size fits all. There are special circumstances that occur, and Matt and I have heard more than our share of special circumstances that occur with these tax foreclosed properties, such that case by case, you have to have that conversation with corporation counsel to make a determination of what rights are involved and what the county ought to do in order to ensure compliance with Act 207 and ensure compliance with Tyler. Matt, your thoughts?
Yeah, I mean, I think what I would say is with respect to the effective date and tax deeds acquired prior to 2022, I think there are likely arguments on both sides as to whether or not those deeds need to be published for sale. And like you said, Andy, I think the right people for folks on this call to talk to about that are the corporation counsel. But I would say that's an open question right now that'll may or may not be addressed in the future.
So again, on the requirement to sell, we have the question of what about those deeds that you acquired prior to April 1, 2022? Second question, what about property that a county transferred to a municipality for no consideration? Is there anything that we have to do to go back in time to either implement Tyler or implement Act 207? I don't think we go back in time to implement Act 207 if we disposed of that property prior to the effective date of Act 207, which was April of this year. But from a constitutional standpoint, is that something you want to examine? Potentially. I think it depends upon, again, a variety of factors, but that's a conversation with corporation counsel. What about property that the county retained and wants to retain? That's, again, a conversation with corporation counsel, because again, you want to make sure that you're not only implementing Act 207, but you're also implementing the mandate that the Supreme Court issued in the Tyler case. Act 207 also gives rise to a right of the former owner to repurchase the property. From a county standpoint, I think that the best situation that we could ever hope for is that every property owner pays their taxes when due, and we never go through this process. That's the best solution. We are not in the business of being landlords. We are not in the business of wanting to own properties, commercial, residential, or otherwise. We are in the business of wanting to get paid our taxes that are due us for the services that we provide to our citizens. Simple as that. So recognizing that, and then also recognizing the interest from the various constituent stakeholder groups that are out there, there was a significant push to say, look, there ought to be a right to repurchase these properties. And after all, counties, isn't that what you ought to be interested in as well? Getting the properties back on the tax roll, having the former owner make good on all of the past due amounts, and then we just move forward with a clean slate. Okay, sure, that sounds really good in concept. But again, how do you implement that? So Section 7 of Act 207 does impose a mandate that if we have a single family owner-occupied property, we as counties have to have an ordinance on the books that gives the owners, their beneficiaries, or their heirs, and those terms are defined elsewhere in statute, the right to repurchase tax foreclosed properties, but they have to make the county whole for that entire process. All right. The language of Section 7 of Act 207, which created this repurchase right, again, is not perfect. It's not precise, and there are open questions. From my standpoint, from Matt's standpoint, we don't necessarily mind those open questions because you'll see that the implementation of this mandate is through county ordinance. And so I think counties have been given some level of discretion to fashion their ordinance to implement this requirement in a way that administratively and from a county perspective makes sense. So long as you are making your ordinance provide the meaningful right to repurchase, I think you can comply with Section 7 of Act 207. And so we have questions that come up about this repurchase ordinance. Laura opened this entire discussion with a question about the repurchase question. When it comes to, Laura asked, when it comes to the right to repurchase information that needs to be provided to the former owner, the statute is silent as to what sort of procedural notice we give to the former owner. That is correct here. Absolutely right, Laura. Again, if it is easy for us to sell to the former owner and the former owner makes good on what is owed the county, that's not a bad result. And so our ordinance ought to address what it is that we are going to do to provide notice to the former owner of the opportunity to repurchase, the deadlines associated with that repurchase right, and then the procedure that the former owner needs to follow in order to take advantage of that repurchase situation. And so again, the statute is silent. We have opportunity within ordinance to define this. And so as counties, it's incumbent upon us to do a good job defining those rights within ordinance. Along those lines, we recognize, WCA recognizes, Corporation Counsel Association recognizes, Treasurers Association recognizes that it would be really nice if we could have at least some common thought on what the ordinance needs to include, some common provisions out there, because having 71 different counties in the same boat as it relates to implementation of this requirement is better than having each county acting differently. So along those lines, there is a working group that has been formed with Corporation Counsel Association and WCA to come up with some template language for this ordinance. We have a meeting to discuss this. I believe it's later this week or next week, where we're going to start working on that sort of template language. It is our goal to have this language available prior to the WCA's annual conference happening in La Crosse, third week of next month. Matt's going to have a wonderful workshop that is dedicated to Act 207 implementation. And at that workshop, he is going to wow you with some of this template language and considerations for your ordinance. And so no pressure, Matt, but you are on the clock for coming up with ways to wow all of the attendees at your workshop to talk about this ordinance and what it means. So let me pause there and see if you have any thoughts on this whole ordinance and repurchase requirement, Matt.
No, I mean, I know we've got some questions in the next couple of slides that we can walk through, Andy. Other than that, I would say that my odds of wowing the audience are higher if I'm not following you. So
There you go. There you go. So when we get to what this ordinance will address and the questions that exist and remain after Act 207, how do we police whether property is owner occupied? What sort of inspection or investigation do we have to undertake in order to determine if it's owner occupied residential property? When is the sale closed? When is the property noticed for sale? Is some other time? Can you cut off repurchase rights at a certain point? All very good questions. All of those questions are not answered in Act 207. And so we have to be very, very careful in our ordinance drafting to define what a repurchase right means and the procedure for a property owner, a former owner, to take advantage of that repurchase right. How do we handle repurchases by heirs or beneficiaries? How do we determine if somebody truly is an heir or beneficiary? And let me just segue for a moment there, because we already have a process in place to determine heirship or beneficiary status. And it may not be the same in every county, but we already have this unclaimed funds concept under 59.69, I believe it is. And that unclaimed, or 59.66, and that unclaimed funds process does recognize in certain counties the right of an heir or beneficiary of the person that has unclaimed funds to claim those funds. And so I would suggest that we need to synthesize, if you will, the process that we use for typical unclaimed funds with the process that we use for tax foreclosed properties. But again, that's a determination up to every county. What are the county's costs and expenses? Is there a cap on that? Do we have to be reasonable? Is it going to be compared to anything else? Don't know necessarily the answer to that. What about this whole concept of paying off liens? Because we ultimately don't want somebody to repurchase the property just in an effort to clear title to the property so they don't have to pay their bank, they don't have to pay the person who put the roof on their home and so on. Well, the statute does say, Act 207 did say that we have to clear out all liens. We impose that burden upon the former owner, so it's not a county burden. But how do we verify that those liens have been paid off? And for that matter, how do we verify what those amounts are? And so again, we don't want to undertake an administrative burden on the part of counties. That was part of our concern with Act 216, is that counties were being forced into the position of playing the settler, if you will, on these various liens and issues that arise as it relates to title to property. We don't want to do that. And so Act 207 imposes this requirement that we pay off the liens, but does the ordinance provide an opportunity for us as counties to define that process and what that looks like? My answer is yes. That's what we want to define in the ordinance. Can we require prepayment of title costs? Absolutely. Those are types of things that we can address in our ordinance, and that's what we will address as we go through the ordinance drafting process. Anything you wanted to add on those points, Matt?
no, I mean, I did see a question from somebody on this and whether or not former owners are allowed to purchase the property back mortgage free. And I think that the answer is no. I mean, that's sort of the point of Act 207 and the requirement that former liens be paid off or that funds be provided to pay off the former liens is to prevent that exact scenario. And I think the real question is, what does it mean for the county to pay off former liens? Is it enough that verification of payoff be provided by the purchaser, or are there other things that need to be done?
Yeah, and I mean, Heather asked the question, are judgments against the person considered a lien? It depends upon whether it shows up on a title report, because if it doesn't show up on a title report, my answer is it's not a lien on property, because then you can sell that property free and clear. So it has to show up on a title report in my estimation. Mike Schlock asked the question. Thanks, Mike. When is this going to be available? Because you're always eager to get that information, I know. I think I indicated that Matt was going to wow us with some of that information at his workshop in September. So I think it depends upon the working group that we have put together as to when we'll have a final draft available for distribution. My goal, my thought would be that we get it out by the end of September. Has Heather asked the question, Heather's in St. Croix County, has any county updated their ordinance? If so, would the Corp Council be willing to share their updated ordinance on the Corp Council listserv. I think there are some court counsel out there. I know that Esty in Walworth County updated the Walworth County ordinance, man. I think you took a look at that, if I'm not mistaken. And so Esty, if somebody wants to get in touch with her, absolutely, I think sharing information is going to be critical. And of course, that would help us tremendously in coming up with some sort of template language to put together the best and the brightest ideas that we have out there and put them into that template ordinance language. Patricia asked the question, if there was a lien on the property like a mortgage, that's forgiven when we take the property. It's not necessarily forgiven. It's just that the mortgage holder no longer has a mortgage on the property. The underlying promissory note might still exist, which gives rise to an independent obligation to pay separate and apart from the mortgage. So I just want to clarify that's not necessarily forgiven. But the question is, so the former owner is allowed to repurchase the property mortgage-free and only pay the county's expenses. Am I understanding that correctly? Patricia, that's the concern, is that when the legislature put the repurchase requirement into Act 207, they wanted to make sure that somebody wasn't going to skip out of town, so to speak, on their mortgage obligations. So they're requiring clearing all liens. Now, it doesn't define in Act 207 when that lien had to exist. But to me, it's the liens that were on the property prior to the county taking the deed. Because you're right, when the county takes the deed, that deed is free and clear of all mortgages or other liens placed on the property. That's what foreclosure is. We foreclose out all other rights that are available, or excuse me, that exist as it relates to that property. And so we have to go back in time prior to the county taking the deed and determine who was a lien holder there. Go ahead, Matt.
Well, I was gonna say, and then there's a subsequent question from Amy. You just clarify your position is that all liens are not extinguished at the time of default judgment. No, like all liens are extinguished at the time of the default judgment, as I understand it, when the county takes possession of the property, right? The issue is, I think, as the prior question indicated, that creates an issue when you then give the former owner repurchase rights, because then they could take advantage of that situation because the liens are actually extinguished. So the situation in which we find ourselves is that, yes, the liens are extinguished, but for a former owner to repurchase the property, they still need to pay off those liens, even if they are extinguished as to the county. Is that your understanding, Andy? That's my understanding.
It is, yes.
Yeah, I think, and the questions surround how do you effectuate that payoff? Is it something the county needs to do with funds that are provided to the county by the former owner? Or is it something the former owner can do and then come into the county and say, here's the verification. I've paid off all these liens. Give me my right to repurchase.
No, that's right. And I mean, understand too, that this whole issue with paying off liens, it doesn't exist anywhere else except for those properties that are residential, owner occupied, period, end of story, full stop. If the county wants to extend the right to other properties, Act 207 allows the county to do it, but it's not mandated, all right? So remember, Act 216 from 2021 said that the counties are going to pay off these liens regardless of the character of the property. And we as counties were saying that makes no sense. There aren't any liens that exist because we took a deed after a foreclosure process that wiped out all those liens. So this is nonsensical. How do we implement this? We got that requirement taken away in Act 207. It eliminated that requirement in Act 216. The only thing we have to deal with is the liens that apply on properties that were owner occupied, residential, where the former owner wants to repurchase. In order to exercise the right to repurchase, you have to demonstrate to us that you've taken care of those liens. How you demonstrate that, what that involves, that's the ordinance. That's what we have to come up with language to implement. So again, I just want to make that clear. Tanya just notes in regards to the advertisement requirement relating to 180 days in 2026, we need to watch how many days we give a former owner to repurchase. So we have time to get a value on the parcel and advertise it before 180 days are up. 100%, Tanya, is that the time clock associated with providing notice of opportunity to purchase is not told or stopped while we are giving somebody the right to repurchase that property. So we have to be very careful in our ordinance to build out a timeline that makes sense and is administratively feasible. Terry says she likes the former owner doing it and providing proof. That way we're not getting involved with a lien holder. Lien holder we don't really owe money to. Terry, 100% amen. Thank you for noting that, because I want to reiterate that point, is that I don't think counties ought to be in the business of determining winners and losers when it comes to paying off liens, nor do we want to be in the process of determining the exact lien amount. I think if anybody who's seen a title report has seen that on that title report, it's going to list a lien and the amount of that lien. Just because that lien is listed within an amount on the title report, that's not necessarily what is owed on that particular debt. It may be much less than that. We don't want to be in the business of verifying that. And so we want to the extent possible, transfer the burden associated with that determination to the former owner who wants to exercise the repurchase right. Yeah, Amy noted, you're absolutely right, Amy. We're not required to pay off liens if we sell to an unrelated third party. Price County Corp Counsel Megan, has anybody worked out the timelines for the ordinances, or is that still in process? I will tell you, Megan, that from our perspective, it's still in process. I don't know if other counties have gone through that exercise. Again, I will encourage everybody to share as much information as possible regarding this. And Megan, if you have ideas, certainly send them to me, to Matt, so that we can work with the court counsel group on the template language. Like I said, we're going to get together soon to start talking about these issues. And if Megan, you want to be part of that group, shoot me an email and we'll certainly put you on that discussion as well. All right, so let's talk a little bit about treatment of surplus proceeds, because that changed with Act 207, and you kind of teased this issue earlier, Matt. Act 216 had a 5-year hold requirement. And so prior to Act 207, the county had to retain the proceeds for 5 years until it could deposit those proceeds, so to speak, into the general fund. During that time period, we had to mail the notice of the existence of the proceeds, and under Act 216, it said something along the lines of, if we can't locate the former owner within 5 years, we get to retain the funds. And so the question arose, well, okay, the statute says if we can't locate the former owner, what sort of diligence are we required to undertake as a county to try to locate the former owner? That was an open question. Could somebody come back and claim, well, you didn't do everything that you could have done to locate me, so therefore you owe me my money, even though we're at year 8? And so we tried to eliminate that in Act 207, and I think we were successful in that. The problem is, with getting clarity and making sure that we had a process that we believe passes constitutional muster, from a due process standpoint, we made the hold period a lot longer. And what do I mean by that? Act 207 eliminated that locate requirement, but it said that if after 1 year the property owner has not claimed those funds, then we transfer those funds to unclaimed funds under 59.66 sub 2. And then we hold that money in unclaimed funds. And if the unclaimed funds hold period has expired, then we get to retain the money. Well, what's the statutory hold period for unclaimed funds? It's 10 years. So we've taken a 5-year process and turned it into essentially an 11-year process. Again, not great. It's waiting a long time for those monies to revert to the county. But from a due process standpoint, from a procedural certainty standpoint, I really like what Act 207 did. It makes it very clean and clear that we are to take that money, send it to unclaimed funds, dispose of it through that process, which again, that process has existed for many years. And so from a procedural and a due process standpoint, very comfortable with that process. Any thoughts on that, Matt?
No, I think it's really a matter of uniformity. And if we're doing what's done with other types of unclaimed funds, you're far less likely to have an issue, I would say.
All right, so we talked about 216 and the elimination of the requirement to pay off liens. We've already talked about that. We do have the ability as counties to petition the court for relief from the deadlines. And so, like I said early on, there are unique circumstances that occur with these properties that we acquire through the tax foreclosure process. If we have one of those unique circumstances arise and we simply cannot comply with the 240-180 deadline requirements, then we have the ability to go to court and ask for relief. Act 207 doesn't tell us what that looks like. And some of you lawyers out there might say, well, how does that work? Because if we had proceeded in rem, we didn't get in personam jurisdiction over somebody. So how do we even serve them with a notice that we are seeking relief from the deadlines? Simple answer is, I don't know exactly how that's going to be implemented. I think that's further discussion that we have to have about what that petition looks like and what our requirements are from a due process perspective, make sure that we notify either the former owner, the estate of the former owner, or somebody of our request that the court relax the deadlines that are contained within Act 207. But it was important from our perspective to at least have some sort of mechanism where we can petition for relief from those deadlines. This is important too. 75.35 sub 7 was amended in Act 207. The underlying language is what was added. We wanted to make sure that if we were making good faith efforts to comply with the statute, that we weren't going to get sued by not providing all of the notices and so on that are contained within Act 207. So again, 7535 sub 7 says, absent fraud, no county is liable for acts or omissions associated with the sale of property under this section, including the process by which the property is sold. So we do have a statutory defense there. Importantly, the statutory defense is going to have zero effect on a constitutional claim. If there's a claim that arises under the United States Constitution, this statutory defense isn't going to apply. You can't have a good faith defense to a constitutional violation. That said, if somebody comes back and says, wait a second, it says right here in Act 207 that you had to provide this notice within 240 days. You provided that notice on day 241. I don't care what your excuse is. I'm holding you responsible. You owe me the money. I'm not saying it's a winner, but we have a defense here that if we proceeded in good faith, no fraud, that we have a statutory recognition that we aren't going to be, our feet are not going to be held to the fire there. Again, talking about the concept of 207 compliance with the Tyler case as well. I want to take just a moment here and see if we can run through some of the chats and the Q&A if we can before we get into, Matt, the process you put together, just outlining the steps necessary to dispose of tax foreclosed properties. Janie notes, so in rem eliminates liens via judgment. Does that affect any lien payment? No, we don't have to pay off liens. Again, the only situation where liens are paid off is when we have residential property owner occupied where somebody exercises a right to repurchase. Rhonda notes that Ozaukee County has updated their ordinance. Great. Rhonda also notes that there ought to be certain statutory provisions that relate to some of these issues. I agree with you, Rhonda. I think we started with the conversation that we need to go back to the legislature for certain things. Amanda notes that our current ordinance has us vacating the judgment if a former owner repurchases a property, which then puts all the liens back on the property to her understanding. Would that fulfill the requirement of the lien requirement now? I think that's a workaround on Act 207, Amanda. But I see that workaround as workable, if that makes sense. So in other words, if you vacate the judgment, the liens are reimposed on the property, and then that property owner has an obligation to pay off those liens to clear title. I think that's fine. Or if there is an understanding that former owner is going to make good on the back taxes, judgment is vacated, liens are reimposed on the property, and the lien holders then have a right to proceed against that property. I think that's okay. Matt, any thoughts on that?
Yeah, I mean, I would talk to your corp counsel about that. The only question I would have on that is how it relates to state law, right? Because state law does vacate, or excuse me, state law does clear the liens. And I guess there, could be a question as to whether or not a county ordinance could essentially vacate that judgment. But I think that's something you would want to talk to your corp counsel about.
Agreed. Adam has a good question. What about this whole brownfields issues where municipalities are provided with certain protections, but a private owner doesn't have those protections? There are certain statutory mechanisms where a county can avoid taking title to what's considered brownfields property and actually transfer the right to take title to that property to a private third party prior to the foreclosure process actually being finalized. And so those provisions, those situations, those were not altered. If you have specific questions about the implementation of those statutes, Adam, I would suggest a conversation with Corporation Counsel because again, the circumstances surrounding how you take advantage of some of those statutes, those are unique to certain properties on a case-by-case basis. Let's see here. Sarah asks if the residential property has not been lived in for a couple of years, is it still considered residential? And do we have to notify the former owner that they are allowed to repurchase the property? Great question, Sarah. When does residential property lose its status as residential or lose its status as owner occupied? Again, I'd have to think about it a little further, and that's something I'd want to talk with the court counsel group about, is that do we define what owner occupied means? And does owner occupied have an independent definition under Wisconsin statute? I think that's something that we ought to think about a little bit more. As it relates to the notice that would be required of the former owner to repurchase the property, Act 207 doesn't impose a notice requirement on counties, but I think it would be helpful in ordinance if we identified what notice is going to look at like and the timelines associated with that notice. Any thoughts on that, Matt?
No, I agree with that.
Janie asks if there's a primary resident, the court judgment made to the county and there's a buyback option, how does one guess if they will make payment versus eviction notice possibility? Great question, Janie, and I think that we have to think about that and consider within the ordinance how we establish that timeline for the former owner to exercise the right to repurchase, and then as well, if they don't, even if they say, hey, I intend to repurchase, at some point that 240-day clock, or January 1, 2026, that 180-day clock, it's going to expire and it's going to trigger an obligation on our point to list that property for sale. So I think within the ordinance, we have to be very careful about how we build out that time frame and that timeline. I want to address a question that Renee asked. It's not a topic that we have discussed as yet, but she asks about this whole concept of disposing of the actual property itself. On the first attempt to sell the property, we have to reject every bid that's less than the appraised value of the property. Second attempt, we can accept the highest bid even though it's less than appraised value, as long as our oversight committee agrees with that. If the committee, who has statutory authorization to conduct the appraisal, agrees the value is much less than the assessed value, can we use that value in the first sale, hopefully eliminating a second sale? You can, and I hesitate there by saying you can, because at some point, if that committee sets the value too low in terms of the appraisal, it may give rise to a claim under Tyler that is a taking, because the committee set the value at which it was going to sell at far less than fair market value, and fair market value is the ultimate determinant of the value of a property for purposes of evaluating the takings claim. And so again, I would be very careful about how much discretion we provide to that committee and what we do as it relates to that sale process and establishing appraised value. Any thought on that, Matt?
Yeah, I would say even beyond Tyler, I mean, there's just general principles that, a county committee or a county board can't abuse their discretion, right? So I think the answer is, yeah, if your committee is the committee that determines the appraised value of a property, I mean, they determine what the appraised value of the property is for purposes of the notice of publication of sale, but they can't be setting an unreasonable appraised value as a general matter.
Totally agree. Now, Matt, I'd like you to run through these steps on disposing of tax foreclosed properties. You did a nice job putting this together. This slide deck is going to be available with the recording of this webinar on WCA's website, wicounties.org, following at this presentation. And so you can download and take a look at this. But why don't you just run through this whole process quickly, Matt?
Sure. I mean, this was an attempt to sort of synthesize everything relating to both the dealing with the surplus issue and second, just generally dealing with how you dispose of tax foreclosed properties. Some of which is, has been around for a long time. So, upon acquisition of the tax deed, you still have to provide notice to the former owner of the right to potential surplus proceeds. As Andy mentioned earlier, I think there's a question of the extent to whether you're required or should also provide notice of the repurchase rights. But that's something that I think, as Andy indicated, you can deal with in your own local ordinance. So then you have your local ordinance that you're going to have set up for ensuring the right of a former owner to repurchase the property. There are statutory provisions. I don't think any of this has changed regarding providing notice to other taxing jurisdictions of special assessments, special charges that are unsettled with those jurisdictions. The advertisement and appraised value of property, that's all the same as it was before, except we now have these time requirements on when it needs to be done. And there's the requirement that you do it more or less with respect to all properties. I will say there is a question relating to whether or not this is required, whether or not notice and publication is required if you're going to sell to a municipality. And the reason why that is still a question is there is still statutory language in 75.69 excluding sales to municipalities from the 75.69 process. So that is something that I would say you should discuss with your corporation counsel if that's something that goes on in your county. But assuming you're going through the typical 75.69 process that applies to sales of tax delinquent real estate, first attempt to sell, you advertise appraised value by publishing on the website, either publishing a class 1 notice or advertising on MLS. We talked about that before. You need to reject bids less than the appraised value. Again, what your appraised value is set at. It can be a county board, it can be a committee, it can be an appraiser doing an appraisal process. But if the bids you receive are less than the appraised value on the first attempt to sell, you must reject. And if it's above the appraised value, you must accept the highest bid unless the county board explains its reasoning in a written statement. None of this has changed. I think this is all consistent with the process under prior law. Subsequent attempts to sell may be advertised through publication of a class 1 notice. Subsequent attempts, it's still the same process as before. You can sell for less than appraised value if the county board or designated committee reviews and approves the sale. Highest bid must still be accepted unless the county board or designated committee provides a written explanation for why it's doing that. And I think the rest of this stuff is consistent with prior law regarding notices of sale to municipal clerks. Determining net proceeds of the sale by subtracting the costs of the sale. There's a process in state law for doing that, determining surplus proceeds. Most of this is consistent with what was previously set forth in Act 216 from a couple of years ago, with the exception that we're now no longer dealing with the former liens as part of this process. We talked about that previously, but essentially the goal here being that any surplus proceeds that you are sending back to the former owner I would say, it's ensuring that the county is made whole for having to go through the process, right? So you're getting paid your delinquent taxes, you're getting paid the interest, you're getting paid the penalties, you're getting paid property taxes that would have been owed on the property, you're getting paid the costs that you've incurred to deal with the property. And it's only at that point that the former owner is getting their surplus. So
I will say, we did address that a little bit in Act 207 because there was a discrepancy in Act 216 where one provision said that you could charge back to the property the fees associated with a real estate agent or broker. And there was another provision that said you couldn't do that. And so Act 207 makes clear that any fees you incur in engaging a real estate broker or agent are chargeable back to the property. So we tried to clean up and provide additional authority for counties to make sure that any amounts that the county was incurring, any costs that could be charged back to the property are able to be charged back to those properties.
Then, as we discussed previously, if payment is returned to the county or otherwise not claimed by the former owner within 1 year, it goes to unclaimed funds. And the county treasurer should dispose of those funds as provided in state law for other unclaimed funds.
All right. Thank you for running through that, Matt. As I indicated, those steps will be available within the slide deck on Wisconsin Counties Association website. And so we are at 9:59, meaning we've got 1 minute for open Q&A. So we'll leave this open for a couple of minutes here to see if anybody has any questions, comments, whatnot as we go through this. While we're filling a little bit of time here, it's a reminder to everybody to be on the lookout for the template ordinance language that will be coming out hopefully within the next month and a half as well. It's a brief plug for attendance at the WCA's annual conference in La Crosse beginning next month. I believe that's on September 22nd, if I remember right. yeah, 22nd through the 24th, where this topic, among many others, is going to be a topic of conversation. I don't see any other questions, comments, or anything else coming in. So if that is all we have, we will end this webinar now. And I want to end by saying thank you to everybody who is very interested in this topic, because implementing some of these laws, it's not easy. And so I want to thank everybody for their interest in doing this and in doing things the right way. So if you have any questions, follow up that you think about 10 minutes after we end here, feel free to send an email to me and to Matt, to WCA, and we'll certainly get information to you as soon as we can. Thank you all for your assistance again. And can we post a link to the conference? I'll ask Anne Marie or WCA if there's any way to post a link in the chat to conference registration, if that's still available. See if we can do that. And so if we look at the chat right now, we've got WCAconference.com. That's the link that you follow to register to the WCA conference. All right. Thank you all very much again for participating, and we look forward to seeing everybody again next month. Take care.